Hi, this is Armando Romero, broker of BrokerNation Real Estate. Thank you for tuning in for the contract training. First, I want to do a disclosure, let you know that I am not a legal attorney, so I'm not going to make legal representation. I am going to make broker representation. 30 years in this business, what I've learned, and it's very important, even if you know the contract, to listen to what I'm going to say. I'm going to share with you my experience as an agent, as a broker, of things that I do on the contract and ways that it would help you negotiate better. So let's get started. The first thing that I recommend, whether you're a new agent or experienced agent, if you haven't done it already, is to get the as-is contract or sales contract and take some time and read the whole thing. I'm going to cover highlights of the contract. Obviously, I can't go through every single, and I'm not going to read the whole contract, but whenever you have a chance, it's important that you read it. One of the things that, as an agent, your job and your duty is to be able to represent the contract and be able to guide the timelines of the contract. We always talk about what is the agent's duty. A lot of agents get out of school, they basically start selling real estate, and they never take the time to really analyze what their duties are, what the role is. And the role of an agent is to make sure that whether you're representing the seller or you're representing the buyer, that you always stay tuned and up to date with contract changes, and also that you manage timelines in the contract. So I'm going to go over some basic stuff, but I'm also going to go over some detailed stuff that if you're an experienced agent, I strongly encourage you to watch this training. So let's get started. The first thing is the contract's very simple. At the beginning, you just fill in the buyer and the seller. I usually put and/or seller of record. Sometimes, you put a tax roll, or you pull what the owner's name is, and you're not sure if somebody else is the owner, if it's an LLC. So I would put in there the name and/or seller of record. Then you fill in the buyer's information, property description, make sure you're thorough with the property description. You put the folio number, which is required on the contract, and you get the legal description, you put it in here. Personal property, usually there's your standard, the contract covers most of the personal property that's in the offering. You look at the listing, whatever's included, you make sure you double check with the other agent. Any other additional stuff that may be included. You may have jacuzzis, or you may have other items, outdoor kitchen appliances that you would go ahead and include down here. If there's stuff that's excluded, make sure that it's listed in the contract. Okay, purchase price. I always fill in, obviously, the purchase price here. Now, initial deposit, and especially when you want, if you're representing a buyer or you're, making representations, trying to get this deal done, you want to make sure the contract's as solid as possible. So if it's a deal that, you're trying to get, you're battling between other deals that are going to happen, you want to make sure you got enough deposit at the beginning to make this contract strong. So the initial deposit, I usually put within 3 days. So you got to check this box here. Within 3 days of effective date, the buyer is going to go ahead and put a deposit. Then additional deposit will go down here on B. Then you also put, obviously, the title information, the attorney information in here. Again, making sure you're thorough, put telephone number, emails. And then the additional deposit, I always want to make it a little bit after my inspection period. Typically, inspection periods are anytime between 7 to 15 days. Let's say this one's 10 days. I'm going to make my additional deposit to be 12 days. And the reason for that is because I don't want my deposit to be given in between the inspection period. There's no point, if the buyer's going to back out of the deal, to be giving deposits and then have to give the deposit back. So in this particular case, I put $25,000 and I put another $25,000 after the inspection. Usually you want to get anywhere between 6 to 10% deposit. Now, if it's a FHA financing, or if it's something which is 3% down, the buyer doesn't have that much money, then you want to, get around 5%. But never put in here $5,000, very little. Try to put as much as you can in the beginning. and then a little bit after. As far as financing, a lot of agents put the number here and then they put the balance down here. The problem with that is when you do that and you start negotiating, then if the price changes, then you got to change everything else. So I usually like to put the percentage of financing, and then I put balance here. So if this changes, let's say 520,000, it's not going to change the percentage, but it's not going to change the balance here. Time of acceptance. It all depends on the motivation. It all depends if there's multiple offers, but I usually want to get an answer as quick as possible, and I also want to give enough time so that my time of acceptance doesn't expire. So anywhere between 3 to 4 days is a reasonable time. If it's over a weekend, maybe you can put a couple days after, but I want to give enough time so that we can go, and whoever's presenting can present it and get back to you. Closing date, nowadays everybody wants, close as soon as possible. I usually put here 15 days after loan commitment or financing contingency, or I put on or before. If I do financing contingency of 30 days, I put on or before 45 days. Now, being that we're in the market today, where everybody's trying to get these deals done, the shorter period of time that you put here and also in the financing contingency, the better you're going to be off in making your contract more solid. As we move down, number 7 here, and all this, other stuff here, you can take some time and read it, but it's basically occupancy and possession. Usually occupancy is when funding has taken place after the buyer and the seller has received their money. You can get possession of the property. Assignability, I like to always put may assign but not being released from liability under this contract. If you're representing a seller, never want to accept something where somebody can assign and get released, because they can assign to an entity, or they can assign somebody else, and then you have to deal with the other entity. You always want to give them an opportunity to assign, because sometimes buyers want to purchase a property under an LLC, and that's something that could be assigned at closing, but never released from liability. Now, the financing section, very important. Obviously, if it's going to be cash, you're going to click here. Buyer's going to pay cash. There's no financing contingency. If there's going to be a financing contingency, it's going to be down here, where the contract is contingent about buyer obtaining an approval. If it's conventional, you check off here. FHA or VA, you check out the other ones. And then the financing should always be 30. I feel like 30 days is a good period of time. You're going to get some cases where people say 20 days. That's not very realistic. Usually it takes a minimum of 30 days. If you put 45 days, in some cases, you're going to be chopped out of the contract, because a lot of people want this done as soon as possible. Now, it's very important that you fill in all the empty, I always like to fill in all these empty spots where it says if left blank is 5. So if the buyer wants to apply and is applying for a mortgage, they have 5 days to apply after the 5 days here. This is the other part, the only part that I don't like to fill in, okay? Where it says, the financing is contingent on a certain type of interest, or not to exceed a certain percentage, or not to exceed additional term. Now, I don't put this because then if you have a buyer that's qualifying for a 5.5 interest rate or whatever, well, now today we're 2.5, 3%, and all of a sudden right before they get the approval, they say, well, now I can't get the 2.5, it's 3%. They can always back out of the contract. So you don't want, make those representations, because there's too many variables as far as rates go. Now, is it the responsibility of the buyer to use diligent effort in obtaining a loan approval, okay? So it's your responsibility as an agent, whether you're a buyer's agent or a seller's agent, you have to, as a transaction, you have to always keep up to date that the buyer is giving effort or providing documentation that the lender needs. And the way that you do this is you obviously are in communications with the lender. Before any contract is accepted, before you sign anything, you should always have a pre-qualification letter from the lender, making sure that you're not wasting your time and you're not wasting everybody's time with a buyer that doesn't qualify. During that time, it's the responsibility again of the buyer to make sure that they're cooperating with the lender, and always keep the seller informed of the status of the mortgage loan application, loan approval, loan process, and authorizes the buyer's mortgage broker, lender, and closing agent to disclose such status, progress, and release preliminary or finally execute a closing disclosure settlement statement. What does this mean? Sometimes you get a listing agent that will tell you, or a lender that will tell you, I can't release any information. That's a private information between the buyer and the mortgage lender. Well, that's not true, because when they sign the contract, they give authority to the seller's agent to obtain information as far as the status, as far as how the loan processing going. Now, obviously, they can't give you any confidential or private information, but they can share with you how the process is going. Now, upon buyer obtaining loan approval, buyer should probably deliver written notice such approval to the seller. If buyer is unable to obtain loan approval after the exercise diligent effort, then at the time prior to expiration of loan approval, buyer may provide written notice to the seller stating the buyer has been unable to obtain loan approval and has elected either. Now, we are transactional brokers, as you know. We represent the transaction. If you're dealing with a transaction where you're the listing agent, it is also your responsibility to stay up to date with everything that's going on. Now, if you're representing as a buyer's agent and you're representing the buyer's side of the transaction, then it's important that you as an agent keep the listing agent informed. Now, as a buyer, you have to deliver a commitment by the 30 days or the 45 days. It's your responsibility to deliver that commitment. If you do not deliver that commitment, then the seller can say, well, then you never deliver it to me, then it's waived. But the seller also has the right to cancel the contract. And this is something that a lot of agents don't realize. So the seller may waive the contingency, but the seller may elect to terminate this contract by delivering a written notice to the buyer within 3 days after the expiration of the loan approval period. This means if you're a buyer's agent and you're not up to date and the loan commitment expired, and a week later you decided like we're moving forward, and all of a sudden you get a notice from the seller say, I'm canceling this transaction because you never notified of the approval, they have all the right in the world to do so. So it's very important that you communicate. Once you get that loan commitment, you send it over to the seller's agent and make sure the seller gets a copy of it. If you have not obtained a loan commitment, it's very important when these timelines happen that you communicate and you either ask for an extension or back out of the deal. As an agent, it's your responsibility. Remember, buyers are, depending on your experience as an agent, so it's your responsibility to make sure that these timelines do not expire and that the buyer may lose their deposit. It's your responsibility to do this. Okay, next one is the contract timely terminated, provided paragraph 8 and above, the buyer is not in default on the terms of the contract. Buyer shall be refunded the deposit, hereby releasing buyer and seller from further obligations for this contract. So if you've done it within that timeline, then the buyer will get their deposit back. If the loan has been obtained and deemed to have been obtained as provided above, and the buyer fails to close on this contract, then the deposit shall be paid to seller unless failure to close within due to the following. So there's certain situations where the buyer will go ahead and get approved. Everything, they'll have conditions, and all of a sudden there's other things that can, like title or any kind of liens or any other conditions that can stop that loan approval. Status changes. One of the things that it's in here, and I'll read, is seller's default, inability to satisfy other contingencies of this contract. Okay, that will be a way that the buyer can get their deposit back. The seller cannot provide clean title, and cannot comply with their obligations, then the buyer can elect to get their deposit back. The next reason, property-related conditions of the loan approval have not been met, except when such conditions are waived by the provisions of the contract. Okay? Appraisal of the property obtained by the buyer's lender is insufficient to meet the terms for the loan approval, in which an event, the buyer shall be refunded the deposit, thereby releasing the buyer and the seller from further obligation. What does this mean? We do have an appraisal contingency addendum that we can put, but if you deliver a commitment to a seller, and part of that commitment says, well, is subject to appraisal, then this would apply. It means that they've accepted a commitment, but we still need to do an appraisal. If the appraisal is insufficient, then the buyer can get their deposit back, even after the loan timeline, the approval timeline. Okay, the next section is closing fees and charges. These are the standard fees that a seller would pay, and these are the standard fees that a buyer will pay. In here, we have our company transaction fee to be paid by the buyer. Buyer will pay $4.95 transaction fee to BrokerNation Real Estate. And then if you have the listing, in the listing agreement, you also have this, that the seller will also be paying a $4.95 if that's the side that you represent. Title evidence, again, put in here 15 days. It's the responsibility, obviously, the seller, you're gonna assign a title company, and there's 3 ways to be able to get a title company engaged. And in number 1, it says seller should designate a closing agent, owner's title, and pay for owner's policy and charges. In the state of Florida, if you are a seller and you want to use your own title company and you want to force the buyer to use that title company, then owner's policy needs to be paid on behalf of the buyer. This happens usually on new developments. You go get a developer and they do their own contract, they use their own title company. They usually include paying for the owner's title policy. Okay. The next one, buyer should designate closing agent and pay for owner's title policy and charges for closing services related to buyer's lender's policy endorsement for closing. Or the one that I recommend is the Miami-Dade for our original provision, in which this is the one that the buyer selects the title company, buyer pays their own title insurance, and that way they have control of their transaction. Next thing is survey. Obviously, every property needs to have, if it's a single family resident, you want to get a survey. The lender's going to require a survey to make sure there's no encroachment. Home warranty. Back when I started, we used to have a home warranty companies put in here, and a lot of there was a company called ERA. ERA used to pay for home warranty. We don't really have that today, so you want to put here, check off, not applicable. Special assessments, very important that you disclose this. It's either the seller paying the installments prior to closing, buyer should pay installments due after closing. This is referring to special assessment, like there's white green. White green is which is the PACE program through the state, where a lot of people get improvements done to the property and they're added to the tax bill. Some cases, this could be paid off at closing, or it can stay in the tax bill and the buyer can pay. That's something that you need to negotiate. Number 2, seller should pay the assessment in full prior at the time of closing. So you want to check. I usually put this one, and then if there's something that we don't know about, then it could be negotiated later. Okay. Disclosure, rate on gas, we really don't have that out here, so this is just a basically disclosure. Permit disclosure is very, very important. I strongly suggest you pay attention on this one. A lot of agents think that, the contract, the FAR contract says that, the seller is going to make sure that there's no liens, there's no open permits, and that's not the case. And I'll read it. Except that might have been disclosed by the seller to buyer in a written disclosure, the seller does not know of any improvements made to the property which were made without required permits, or made pursuant to permits which have not been properly closed. If seller identifies permits which have not been properly closed or improvements which were not permitted, then the seller shall promptly deliver to buyer all plans, written documentation, and other information in seller's possession, knowledge, or control relating to improvements to the property which are subject to such permits and unpermitted improvements. What does this mean? It means that, yeah, they can have open permits and the seller is going to cooperate with the buyer, providing any kind of plans or anything that they need to be able for the buyer to close those permits. But it does not give the seller the responsibility to close them, especially from a financial aspect. If we go down, I'm going to skip down to the bottom. In section 20, we've added this. Our attorney has advised us that this should be in every contract. And what does this do? It says, notwithstanding paragraph 12A of the contract, seller should be responsible for any violation of governmental, building, environmental, and safety codes, restrictions, or requirements. Seller should be responsible to close any open, expired, co-citation, co-violation, and or open permits. This provision should survive the inspection period. Seller will deliver clear and markable title. The other thing, during the inspection period, and we'll get to inspection period, it asks in some contracts after the inspection period, you can't go back and say, well, we have an open permit. In this particular case, it's saying it doesn't matter if it's after the inspection period, seller needs to close any open permit. The other reason is a lot of cities require a re-occupancy inspection. I know Miami Shores and North Miami, a lot of the cities require, before you do a closing, an inspection has to be done by the city. And one of the things that they do in that inspection is they make sure that if there's any open permits, the city will not grant you that occupancy. So it's very important that when you have a listing, let's say you get a listing in North Miami or Miami Shores or any of the cities that do re-occupancy, Hialeah, it's very important that when you get that listing, before you get under contract, that you already start the process of finding out if there's any open permits or any code violations or any legal additions, especially in Hialeah, where you see a lot of apartments done in efficiency. Very important that you advise the seller that in order for them to sell the property, they need to make the property, if it's not conforming, put it back to a conforming status. That way, when an inspector goes out, they're assured that this deal is going to be able to be done. Okay. Flood zone, there's properties, obviously this is a flood disclosure. Lead base, there's a lead base disclosure, which is mandatory in properties constructed prior to 1978. Very important that you do that, and I'll go over that in a few minutes. Homeowners association, if it's part of an association, you need to have a homeowner association condo rider or a HOA rider. Okay, foreign investment, property tax. If you're representing you have a listing and you have somebody that lives, let's say, out of the country, there's money that's going to be held back, part of the proceeds. So if I have somebody from Venezuela that owns a property and I'm trying to sell it, usually around 15% of the proceeds to the seller are held back, and there's a process that needs to take place. You can contact our attorney, or the seller can contact our attorney to explain that process. I'm not going to get into it now. Seller disclosure, sellers making representation that they don't have any material facting affecting the value of the property or anything that can hurt, the physical condition or any history of the property. Property maintenance, except for ordinary wear and tear, casualty loss, seller shall maintain the property, including not limited to lawn, shrubbery, and pool in the condition of the effective date. In other words, once you get under contract, it is the seller's responsibility to make sure that when they do a walkthrough, that property is still in the same condition or better than when it was shown. Now, property inspection, right to cancel. Here is when, especially in today's market, a lot of, if you're competing, you want to make this as short as possible. We used to go 15 days. Nowadays, we're going anywhere between 7 to 10 days, and I've seen even less. The reason for that is anytime you go under contract, you're going to tie up that property. If you have a listing, somebody comes in with 15 days, that means that you're going to have to wait 15 days because for whatever reason, okay, and this has nothing to do with inspections. This is an absolute reason the buyer at the sole discretion that the property is not acceptable to the buyer may terminate this contract with a later written notice such election to the seller prior to the expiration of the inspection period. It doesn't mean that just because the property has an issue, physical issue, you can do inspections and everything will be perfect, but the buyer simply decided they don't want to buy the property for any reason. Maybe they have a relative that they don't like that lives across the street. Maybe they just don't like, the traffic. They discover something after that for whatever reason, they don't want to move into that property. They have all the right in the world. Walkthrough, very important. Use an agent, very important. Whether you're a listing agent or a buyer's agent, you always want to do a walkthrough inspection on the day prior to closing date or the closing date. And basically, to walk through to make sure the property is still in the same condition, and you have a walkthrough form signed from the buyer or the seller, and if there's any issues, that could be taken care of prior to closing. Now, earlier I was talking about seller's assistance and cooperation with closing building permits, and this is the part that it says that it's really the buyer's responsibility. So I said, if buyer's inspection of the property identifies open or needed building permits, then the seller shall promptly deliver to buyers all plans, written documentation, or other information in seller's possession, knowledge or control relating to improvements of the property which are not subject to such open or needed permit, and shall promptly cooperate in good faith with buyer's effort to obtain estimates of repairs or other work necessary to solve such permits issued. Seller's obligation to cooperate shall include seller's execution of necessary authorization, consents, or other documents necessary for the buyer to conduct inspection and have estimates of such repairs or work prepared. But in fulfilling such obligation, this is the key, seller should not be required to expend or become obligated to spend any money. Therefore, if you're under contract and all of a sudden you get to closing and you find out there's a bunch of permits that are open and you didn't have the clause that I describing earlier on the bottom, means that the seller is not liable for these open permits and they don't have to spend any money. It's the buyer's responsibility to go out and close these permits. The next section is escrow. You always, here at BrokerNation, we have an escrow account, but only for rental and leasing. We do not have an escrow account for sales transactions. And the escrow should always be, you want to try to get it in the buyer's attorney or the buyer's title company. They're the ones who are going to be giving escrow. Very important that you provide an escrow letter to the seller, and also an updated escrow letter when the additional deposit is due. Number 14 talks about professional advice and broker's liability. And I'm going to read this in entirety. It's very important that you understand your role as a realtor. So it says, broker advises buyer and seller to verify property conditions, square footage, and other facts and representations made pursuant to this contract, and consult appropriate professionals for legal, tax, environmental, and other specialized advice concerning matters affecting the property and the transaction contemplated by this contract. Okay. Broker represents to buyer that broker does not reside on the property, and that all representations, oral, written, or otherwise, by broker are based on the seller's representation or public record. Buyer agrees to rely solely on seller, professional inspectors, and governmental agencies for verification of the property, conditions, square footage, and facts that materially affect the property value and are not the representation, oral, written, or otherwise, of the broker. So if you see a listing that says, there's 5,000 square feet, property that's 5,000 square feet, and sometimes we used to see a lot in the past. Now the MLS is forcing or not allowing agents to put the square footage according to what they want. It usually comes off of the tax roll. So there are some times that the tax roll will say it's less or it's more. It's important that you don't make representations without knowing what the actual square footage is, and basically that the buyer understands that there could be some differences in square footage. So it's up to them to, with the appraisal, when the property is measured, or use an architect to properly measure the property, or any other representation. So it furthermore says buyer and seller individually in the identifying party, each individually identifies both parties and releases broker and broker's officers, directors, agents, and employees from any liabilities, loss, or damage, including all costs and expenses, and reasonable attorney's fees from all levels self-incurred by brokers and brokers' office, directors, agents, and employees in connection with arising from claims, demands, or causes of action instituted by buyer or seller based on inaccuracy of information provided by identifying party from public records, identified party misstatement, or failure to perform contractual obligations, brokers performing identifying parties' request of any task beyond the scope of services regulated by Chapter 475, as amended, including broker's referral, recommendation, or retention on any vendors for or on behalf of identified party. Now, if you're requesting and you're representing inspection companies, I would always strongly recommend that you refer at least 2 companies or 3 companies, because somebody can always say, well, that's a company that my agent referred to. Well, even if the company we refer to, they have their own license, we're not inspection companies. So, in order to avoid any confusion, it's always good to recommend a couple inspection companies. Product or services provided such as vendor on behalf of identified party, expenses incurred by such vendor, buyer and seller each assume full responsibility for selecting and compensating their respective vendors and paying their other costs under the contract, whether or not the transaction closes. A lot of times you have a transaction that's going on and appraisal's done and all sorts of inspections are done. And it's very important that the buyer understands that if for whatever reason they cannot close the transaction and they're trying to get financing and their financing is denied, that they're going to lose whatever they gave up to a vendor, like an inspection company or an appraiser, and that's money that's not refundable. So it's very important that you inform them of that. Paragraph 14, when I relieve broker is statutory obligation of Chapter 475 amended. For the purposes of paragraph 14, broker will be treated as a party to this contract. This paragraph 14 shall provide closing termination of this contract. Okay, moving on. Default. Obviously, if the buyer fails or neglects or refuses buyer's obligation, they can lose their deposit. So there's timelines, and that's what I said when we started this training. It's very important. That is something that you do have a responsibility as an agent to make sure that the buyer, whether you're a transactional agent or your buyer's agent, that the buyer does not miss a timeline. If it's a response, they have to give a deposit by a specific day. It's very important that you communicate that they have their deposit is due, the additional deposit is due. If they have to apply for a mortgage, it's very important that you communicate that. If they have a loan contingency, an inspection period, it's very important that those timelines are met. If they're not met, then you need to communicate via email, letting them know you're risking losing your deposit. We need to either cancel or we need to get an extension. And you need to communicate that to the other agent as well. If you're the buyer's agent, you need to communicate to the listing agent. We don't have a loan commitment yet. We're going to need another 3 days. We're going to need another week, whatever it may be, as long as you document that you are doing your job to make sure these timelines are met. Seller default, obviously the seller decides they don't want everything's been done, and the seller does not want to sell the property anymore. You see this sometimes, especially now that you have a seller's market. They're looking we've seen cases of sellers trying to get out of the deal. The buyer can sue the seller for non-performance. So if the seller's in breach of the contract, buyer may seek to recover damage from the specific performance. Okay, everything else, attorney's fees, each party is going to pay their own fees. Any code violations, number 18, anything like that will prevent the property from selling. The next part I want to talk about is calendar days. Our contracts are based on calendar days, and everything, and I'll read it entirely here. Calendar days should be used in computing time periods. Time is of the essence in this contract. Other than time for acceptance and effective date as set forth in paragraph 3, any time periods provided for or date specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, will show and occur on a Saturday, Sunday, or a national legal holiday shall extend to 5 p.m. where the property is located to the next business day. So we're talking calendar days. If the calendar days get to a Sunday, then it extended to the next day, or if it's in a national holiday, it extends to the next day at 5 p.m. Force majeure has to do with any kind of, during COVID, there was a lot of sellers or buyers that were using this as an act of God, which means the contract is good as long as you don't have a force majeure takes place, which is something like a hurricane, flood, extreme weather, earthquake, fire, or other acts of God. And usually when you have, a war or something like that, somebody can cancel a contract because when they first got into contract, these things were not in effect. So this is something that during COVID, there was some buyers or sellers trying to use this. It was kind of like a gray area because it was not ever listed, but it can be argued that it was something that was unexpected and that it changed the market. And there was a lot of buyers at that time that wanted to get out of the deals, and who would have thought that today, a year later, all these properties have gone up so much. So COVID actually increased the real estate value of a lot of properties. Okay, the rest is closing documents, escrow procedures. We'll just continue through all this. Talks about walkthrough, 1031 exchange. All right, so we're getting toward the end of the contract. Addenda and additional terms. Now, very important, and that's why I put this here. Make sure any addendums are checked off. So if you're doing a condo, you have to check off here a condo rider. If the property is prior to 1978, you're gonna have to do a lead-based rider here. If it's an FHA, you have to check here. If whatever you have, if you're a licensee with property interests, if you're a real estate agent, you're buying a property for yourself, very important that you disclose that you're a real estate agent in the state of Florida. So it's an addendum for that. So whatever addendums you add to a contract need to become part of the contract. What does that mean? It means that if this addendum, you have a condo rider, you check here, and then you fill out the condo rider, but you don't get the condo rider signed, it means this contract then is invalid. Whatever's checked here needs to be dated and signed at the same time of the contract. If I click on here on a condo rider, or I don't do one and I submit the contract, and then I realize, oh my God, I forgot the condo rider. 2 days later, I click here, I go ahead and I do a condo rider. My effective date on the contract is going to be when that condo rider was signed. So it's very important that you check to make sure with appraisal contingency, whatever you're going to put in here gets filled out and signed during the time that you're submitting the offer. This is the additional terms. This is the paragraph that I read to you earlier, which talks about called, expired permits, and then any other additional terms that you may have. Very important. Now, keep in mind, you're not an attorney. You're not, something, you can write something simple, like, refrigerator in the back pergola it's gonna stay with the property. Or, the seller agrees to paint the back of the house, prior to close. You can put things like that. But when you start talking about legal language, it's very important that you communicate with an attorney or with somebody that can help you write that language. In our particular case, we have our in-house counsel, Martha Pozo, who can help you from Nations Trust, and she can help you with that language. Next part is the signature part. And then here, I put here, make sure you put your information and you put the agreed percentage of commission as per the MLS listing. So in other words, I'm gonna put here, if I'm the sales agent, I'm gonna put my name, Armando Romero, and then I'm gonna put BrokerNation Real Estate, 3% or 2%, whatever it may be. Now, that's not really binding, but it's more like a disclosure, okay? Because one of the things that it's important that you realize, the contract is not really we're not involved in this contract. The contract is between the buyer and the seller, and we're just disclosed as the agent, which means we don't even sign the contract. So if I put 3%, it's not really binding, but at least if I put this here and the listing broker has changed their status, maybe it's 2.5 now, then it can be brought up, while the contract's being presented. It's very important, and in the state of Florida, or actually in the Miami board, the commission that's agreed on is whatever's listed in the MLS. Okay, so if in the MLS says that they're going to pay you 3% commission as a co-broker, then that's what the commission is. If it says 2% and you put 3 here, you're only going to get 2%. So it's very important, and this is something that's been brought up. A lot of agents do this. You always keep a printout of the listing, what you got from the MLS. So if you printed something out, then you basically you have it as proof that during the time that you showed and submitted your offer, the commission was 3%. What happens a lot of times, agents will put a property in the MLS, they'll put it at 3%, and then 2 weeks later they change it to 2%. But you had looked at it the week prior, submitted your offer, and then when you get to closing, they say, well, the commission's not 3%, it's 2%. And that's where problems arise. So it's very important that when you submit your offer, you double check with the MLS, you make a printout so you have proof that when you submitted the offer, it was 3% or 2%, or it may be. All right, so we're done with the contract, and now I'm gonna go over the addendums. The first one I want to talk about is the condo rider. Very important that when you do obviously a condo or even association rider, when you do a sale on a house, that this is filled out correctly. Now, usually a condo rider, there's some information you may not have. You may not know exactly if there's any special assessments or what are the type of special assessment. So this is usually filled out by the seller and the listing agent. But I would always submit it with the basic information. If I know if I confirm with the listing agent the association fee is whatever, $350, I'm going to put that on there. But any of the other stuff that has to do with amounts and special assessment, you want the seller to fill it out. So usually when it comes back signed, if there's corrections to be made, they'll make it on there. Association approval, obviously every association usually requires a buyer to be approved with association. So it's very important that, prior to closing, the buyer has that, within 5 days prior, they have the association approval. So it's your responsibility to make sure that they have applied. The listing agent and the seller should provide you with the application process and all the information to get that done. Right first refusal. Right of first refusal means that, in some associations, they have the right to buy a property instead. If somebody brings a contract, they have the right to buy it first. It's very important that you find out this is the situation. And also they have the right to deny somebody from being approved in a particular association. Fees and prorations, here's where you're going to put the association, whether it's monthly, quarterly, or annually. You put it here. This is very important, and that's why I highlighted assessments. They could be assessments that can be in place, or they can be assessments that are coming on their way. So sometimes an association has a meeting, they say, well, we have to do our 40-year inspection, and we expect that we're going to do an assessment in 6 months of, whatever, $35,000 per unit. So if this is the case, it's the seller has to disclose this to the buyer, and then this needs to be negotiated. Who's going to pay for any existing or any future assessment? So if there's a future assessment coming and it hasn't been levied yet, then the buyer obviously will have to pay that when it comes. If it's something that's already has been taking place, then it could be negotiated whether it has to be paid at closing, or where it has to be paid in monthly payments. Usually if it's monthly payments, the seller's going to pay to the time of closing, and then the buyer takes over and continues the monthly payment. Or it can be negotiated where the seller has to pay the whole thing at once at closing. So that's why it's so important that you know prior to that. I had a situation in a condo that I did in the Palace in Bal Harbor, where there's an assessment that actually took place during the contract while we were under contract, but it was disclosed prior to. The funny thing about this assessment is usually associations, when they have a big assessment, let's say $38,000, $50,000, the existing owners are given the opportunity to either pay it all at once or pay in installments, let's say the next 5 years. The buyer, however, in this particular building that I did, because it was a change of title, they did not give the buyer the same opportunity as an existing owner. So my buyer actually had to pay $38,000 to pay an assessment at closing. And a lot of buildings are doing that when there's a title change. So it's very important that you ask and find out if there is an assessment, what is going to be the process. You don't want a buyer coming after you and telling you, well, I had no idea this was going to happen. You want them knowing prior to getting into a contract with this property. So the rest of the stuff is obviously the buyer has the right to receive the information, declaration of articles of corporation. So it's very important that if you're the listing agent, you get the condo docs, the budget, all the information that a buyer needs, and that you deliver that. Buyer has a right to cancel a contract within 3 days if they decide that they don't like the association, or they didn't receive these condo docs. Then down here you have seller's expense to current copies of the condominium documents. I've seen listing agents that say, "Well, call the association. They have condo." No, it's a listing agent, the seller's responsibility and expense to provide copy of condo docs to the buyer. Now, the buyer can request to get them, to receive them, or request that they don't need them. So they request, they're opting out. If they do get a copy of the documents, it could be either listed here, or there's also an addendum where it says that the buyer has received the documents, and you want to make sure you get that signed. Next thing is there's additional, let's say there's a cabana or there's a parking space, make sure that's listed here with the numbers. And this is the part that you may not have right when you submit your offer, and this is the part that you want to make sure that it's filled out from the listing agent or the seller. Okay, the next thing is the debt base. Very important. And I put this because I've seen so many lead base with missing initials. It's crazy. And this is something that needs to be properly filled out. Any initials or signatures and addendums are missing can change the effective date. So there's a lot of initials here. There's a lot of stuff that needs to be signed also by the listing agent and the selling agent. Everybody needs to sign. So basically any property prior to 1978, you need to disclose that it could have a lead base. If they still have the original paint, they could, lead bases, as we know, can be hazardous and poisonous in children, and it can make you sick. So if seller knows, seller will have to fill this out. If they have no knowledge, they can click here on no knowledge. If they have available records, they can click on here, but usually they have no knowledge, they initial here. Buyer can either receive copies of the information above, if there's knowledge, or receive a pamphlet, protect your family, or waive the opportunity to conduct a risk assessment inspection. I don't remember the last time a lead-based inspection was done, so I usually, the buyer usually waives that inspection. Most of the properties have been remodeled and repainted, so, but it's very important that they have the right to choose this, okay? And then the licensee you have to sign here. You have to put your initial here, and then on the bottom, you have to make sure whether you're the selling agent or the listing agent, you fill this out. The next one is FHA. Now, if you're doing an FHA loan, I can talk about an hour about FHA loans and what are the difference, but let me make it simple. An FHA loan, it's a government insured loan. So it requires you to have an FHA addendum. Without an FHA addendum, the lender is not going to be able to submit the loan. They're most likely going to ask you for this addendum. So this addendum basically protects the buyer. And the first thing it talks about is that the property has to be in compliance and according with HUD and FHA VA guidelines. And the property must appraise. So you have to put the sales price here. So in an FHA contract, you really don't have to have an appraisal contingency addendum. It's already here. So if it's $500,000, whatever, $400,000, you're gonna put in here $400,000. There are certain fees, prepayments, that the FHA does not allow the buyer to pay. So if you're accepting an FHA contract and you present the listing side, you're the listing agent, know that there's some fees, prepaid fees or junk fees that this FHA does not allow the buyer to pay. So the seller will have to pay on their behalf. Usually they're around $500. I know it says $250 here, but there would be $500. So I would put $500 in here. There's also repairs that FHA requires the appraiser, rotten wood or certain things that in a conventional transaction are not important, but in an FHA transaction, they want to make sure you got broken cabinets in the kitchen or certain items that will not pass FHA guidelines. The seller will then have to make those repairs, and the buyer is not liable to make those repairs. Therefore, in this section, you're gonna put up I usually put $500, the same thing. So there's other things that need to be repaired in the FHA transaction. Let's say it's $2,000. That's something that needs to be negotiated and something that needs to be repaired prior to closing. If not, you cannot close it. Usually what happens, let's say you have rotten wood or you have doors that are missing or closet doors that need to be fixed, and FHA is gonna, if they list it on the appraisal, then those repairs have to be made. And then you have to get an inspection, a re-inspection from the appraiser. The appraiser will have to go back out, make sure these repairs were made, and then you get the clear from the appraisal side, and then you're able to move forward on your deal. Also, again, you need to sign here, and listing agent needs to be signed. That concludes our training on contracts and my 2 cents as a broker of what I've learned in 30 years in the business. Again, I just want to emphasize it's very important that you know your role, that you know your contract, and you know your business. I hope that this training has helped you and will help you become a better agent, better negotiator, and all around a better realtor. So again, if you have any questions on the contract or anything else, always remember that you can reach out to myself, to Daylan from the Doral, or any of the brokers from the other locations. Thank you very much and have a great day.